Okay, all right. So it's recording. So let's go back to our thing. Okay, so let's. All right. So we stopped yesterday. I think we stopped at the scientific statement. I think that's what we were discussing last. All right. So I've just made. I might have made a small misstatement in the previous class. I'm not sure, but I might have said that if I make a statement which is, let's say, this room is very warm. Okay. I would have said this is. I might have probably said that this is not a. This is a subjective statement. I was talking about the subjective assessment of the word warm. Okay. So, but one thing you have to understand is that because these distinctions that we are discussing, we're talking about scientific statements because you can connect it in some way to positive statements. But the point we're trying to emphasize, we'll explain this in greater detail also later, but that all scientific statements will necessarily be positive statements. So make sure you understand this, the scientific statement as defined by Karl Popper, that it must be falsifiable, and as for something to be falsifiable, it has to be very specific. Okay, so that's why that's another property of a scientific statement. So generally all scientific statements will be positive statements because they will describe some state of affairs, right? So a scientific statement will say that Mars is 20 light years away from Venus or something like that. Okay, it's a statement about what is the fact, but that may or may not be true, but you can, because it's so specific that you can identify, you can prove this statement to be false. It is capable of being proved false. That does not mean it has to be false. You understand this point? Okay, very important because it's a general point of importance, because many times you come across people who are talking about making statements pretending to be scientists, but you will find if you really analyze their statements using the Karl Popper standard, you will find that the statement is not and many experts will make statements which are very vague and general statements. So these statements are not capable of being proved false. They are not sufficiently specific, and therefore they are not scientific statements, and that's an important assessment regarding those types of statements. So you should have this idea in your head. Okay, but all positive statements need not be scientific statements. So if I say that this room is very warm, okay, you realize this is actually a positive statement because I'm describing a state of affairs. I'm describing what is. I'm giving you my impression of the room, which is that this room is very warm. I'm not saying it should be colder or it should be bigger or anything like that. There's no should be in it. But it's not a scientific statement, because what is the meaning? How can you prove that my statement is false? Because warm is not specific, right? So I can say that even 5 degrees Celsius is warm for me. Maybe I'm an Eskimo or something like that. So even 5. So therefore you can't prove it to be false because it's not specific enough so that the statement can be proved to be false. Is this point clear? We will come across these kinds of statements very soon in contract law as well. So you should be aware of this kind of distinction, that all scientific statements are positive statements, using positive with a okay. So all scientific statements are positive, but all positive statements need not be scientific. I just gave you an example of a positive statement, which is that I said that this room is very warm. Okay, but that's not a scientific statement because very warm is a subjective. It's not specific enough. You can't prove this to be false. Yes? Yeah. What is the problem, Saloni? Any problem? Okay. All right. Okay. So is this point? So we will make many such statements in the future as we go along. Like we will say that all contracts are agreements, but all agreements are not contracts. Okay. So we will get comfortable with this idea. All right. Okay. Now briefly, I just point this. I'm not going to open this. There's this very nice economics website. Both micro and macro points are handled in a non-mathematical way by this professor in New York. So I think one of the things that you need to have as an MBA student is, even if you're not going in for finance, you should have a good understanding of economics, which people expect because policy questions are involve these kinds of concepts. So both micro and macro. What I would recommend is that if you have any problems with, you can obviously Chaurinder sir has taught you economics. You can go and check with him. But this is a useful site because it's a non-mathematical treatment, but conceptually it handles all the concepts that are involved in micro and macro. So you can, if you feel more comfortable with a non-mathematical treatment, which I think actually is it's always better to teach the subject non-mathematically, because you focus on the concepts. You still have to be logical. It doesn't mean that it's easy, right? You still have to understand logically the concepts. But this is a non-mathematical treatment of economics, so you can use this resource. Remember, this is again one of those things where I'm like your coach. I'm telling you that in your spare time you need to work on your backhand. So this is stuff that you have to do on your time, on your own time. Okay, it's your responsibility. I'm telling you, this is something people expect, so you take care of it. How you do it is your problem, but you find time to make sure that you are very well versed in all the concepts. And this is also a way of checking if you can figure out all the concepts in this resource. Okay, it's a way of being sure that, okay, I have some basic knowledge of economics, micro and macro. Okay, you understand what I'm saying? It's your responsibility to tell. And if you have questions, you get stuck, you can ask Chaurinder sir, you can ask me. All right, so we'll move on with our discussions. Now what we are discussing is similar topics, okay, similar distinctions. We started with normative versus positive, and now the second one in that set is descriptive versus prescriptive. Okay, so these are not exactly similar, but they are quite similar, so that's why we are discussing them together. Okay, so in descriptive versus prescriptive, does anybody want to hazard a guess which of these is more like normative and which of these is more like positive? Yes, Monira? One at a time. Yeah, don't have to get up. Just sit and answer. Yeah.
Normative is prescriptive because it should how it should be.
No, normative you're saying is prescriptive. Okay, and descriptive is positive. Okay, anybody else with a different view? So Monira is saying that normative is more like prescriptive and descriptive is more like positive. Anybody else with a different view? Yeah, pretty much everybody agrees. Okay, so that's what it is, because when your doctor prescriptive, you remember you have a prescription from a doctor, so the doctor says you should take this. You don't have to take it. You can, many times we ignore the prescription. Okay, so therefore the doctor says you should take it. So prescriptive is, remember, normative is something about, some statement about how it should be. Okay, how it ought to be or how it should be. So prescriptive is therefore more like normative. Okay, we will see these words being used later on very soon. But the point to remember is another distinction that people make, descriptive versus prescriptive, is very similar to normative versus positive, because I just gave you an example. The statement, this room is very warm, that's a descriptive statement because I'm describing the state of affairs in the room, and that's a positive statement because it describes the state of affairs. It does not talk about what ought to be or all that. Okay, so this is clear, the first set of distinctions. We'll move fairly quickly with this. If you have doubts, you can ask questions, and then you can revise, of course, and ask questions again later on. Subjective versus objective, which do you think is there? Again, as I said, they're not exactly the same, but they're similar. If you had to match subjective versus objective against normative versus positive. Yeah, okay, subjective is normative and objective is more like positive. Clear? Everybody is agreeing? You don't have to note this down as such because it's in your notes anyway, but you should be able to see the connection roughly. Okay, let me just reduce the spaces so we can see everything in one. This is one of the problems of putting spaces, that when you want to see everything in one view. Okay, subjective. So what we are saying is, see, again we are saying that these are not exactly the same, but the reason I'm discussing these points is what happened here. 1 minute. No. I just Shubham and what is your name? Okay. That is Varun. Okay. So don't talk. Okay, because I get distracted when I see people talking or doing anything else. Okay. So I'm just coming to Mehul's question. Okay. So what we are trying to say is that these are not similar. These are not exactly the same, but they are similar. So that's why we are discussing them together, because you should be aware of the at the same time you can't say that they are not similar. There is some similarity. Okay, so that's why we want to discuss. So what we are discussing is when you are looking at subjective versus objective and comparing it to normative versus positive, which of these is better matched with normative and which is better matched with positive. That's all we are saying. So what Monira is saying is objective is better matched with positive, because remember, what is subjective versus objective? Objective, so if I say that if I give you an example of instructions, I said if I give you an instruction saying that switch on the AC whenever it gets very warm, that's a subjective instruction or objective? Subjective, because what is very warm? It may differ for different people, right? Very warm is different for different people. But if I tell you that to switch on the AC whenever it goes above 16 Celsius, now that is objective, because 16 Celsius is the same for everybody. Is this point clear? Yeah? Everyone is convinced? Yes? So that's what we are saying. So what we are saying is, therefore, subjective matters are if you have to match subjective with normative and or positive, it's better matched with normative. Because remember, normative statements are about what should be. So they can differ for different people. Right? Like I could say that people should not drink alcohol. Some people might say that why should they not drink alcohol? So that view may not be shared with everybody, so it is subjective. Now people should not drink alcohol, that's a normative statement. Or people should not smoke, that's a normative statement. Right? Are you following what I'm saying? Yes? Okay. So that's what we mean. So subjective here is better matched with normative and objective is better matched with positive. Is this clear to everyone? That's all we are saying. We're not saying that they are exactly the same. But if you had to match them, there is some similarity. Is everyone following? Chinmay, you're following? Okay? Yeah? Nobody has any issues. If you have any doubts, no, don't get scared. Like I'm saying, I hope nobody has any issues. Don't get. So just if you have any doubts at any point of time, some point you feel is not flowing logically from one point to the other, please ask a question. Okay, because as I said, your objective here is not to memorize stuff, but to conceptually understand everything that is being taught. All right. So that's very important. Therefore, to ask questions and clarify your doubts. Yes, Mehul. Doubt is clarified. Okay, good. Okay, so we have one more set of distinctions gone. Now we are coming to one more set of distinctions. Morality and ethics on the one side. So I'm just not going to say ethics anymore. I'll just say morality. But I mean, when people say, okay, your behavior is immoral or your behavior is unethical. Okay. Okay. So these are normative considerations. You can already see this. These are what is moral, what is immoral. Like I can say smoking cigarettes is immoral. Okay. Or so now some people may not agree. So this is a normative. It is matched better with normative than with positive. Right? Okay, and legality is matched better with positive, because legality talks about what the law is, right? What is there in the law, and then if you go out of that boundary, then you're doing things which are illegal, right? So we'll just explain it briefly. I'll just explain briefly first morality versus legality, then we can go back and see this distinction. But what we are trying to discuss is morality versus legality. Okay, so what we are saying here, in a way it's good that we study everything with a multidisciplinary approach. I will take you back to your mathematics set theory. You guys all remember your set theory? In set theory you have elements. You have elements in a set, remember? Every set has elements. Like here if I say section B is a set of students, now section B has 60 students, so there are 60 elements in the set, right? Okay. So what am I saying here? That in the discussion of the morality and legality, I'm saying that the set of all immoral acts. So on one side, if I have the set of all immoral acts, and on the other side I have the set of all illegal acts, what we are saying is that the set of all immoral acts will have more elements. Here on this side we'll have more elements than on this side, which are illegal acts, because many immoral acts may not be illegal. Okay, but most illegal acts are also immoral. You agree with the statement? Generally, murder is illegal. Most people will agree that murdering people is immoral. right? So theft is illegal. Most people will agree. So if you look at most of the things which are illegal, most of them are considered. That's why I said it may not always be true, but generally it is true. Okay, that's why I said is likely to have, right? So if you line up all the immoral acts on one side, okay, you will see that they have more elements. The set of all immoral acts will have more elements in it than the set of all illegal acts. Are you following what I'm saying? Okay, we are doing a refresher of set theory. But so what we say is that another way of saying this, I'm not going to explain it. I did explain it briefly in the other class. So this actually, what this is the illegal acts is actually a strict subset of all the immoral acts. You remember this term, strict subset, from set theory?
Yes.
Okay, so strict subset means the immoral acts contain all the illegal acts plus some other acts, plus some other elements. That's the meaning of subset, strict subset, right? Okay, just to refresh your maths also a little bit. Okay, is this clear now? That's all we are saying, that morality is a broader concept than legality. Okay, so now what we are now I'll just give you the example of one example briefly. Okay, which we still have this on the books. In the Indian Penal Code, there's a section 497 which deals with adultery. But about a year ago, what happened was the Supreme Court in a case has ruled that this section should no longer be considered constitutionally valid, so it is not going to be enforced anymore. Remember that under separation of powers, the role of the judiciary is to interpret the law, and one of the types of interpretation that they do is under constitutional interpretation, like what is happening now also under CAA. There's a challenge to the constitutionality of the act, and then the Supreme Court will decide whether it's constitutional or not. But one of the things they did here was that they said this provision is discriminatory against the woman. So now this is no longer enforced. Okay, this will no longer be enforced. People cannot be punished for adultery anymore. Now, so it is adultery. Therefore, in India is no longer illegal. Okay, and this is these are all British era laws actually. And Britain has also abolished adultery is no longer a criminal offence. It hasn't been in the UK for a long time, but we still had it on the books, and recently about a year ago. So now this adultery is no longer illegal in India. But would you agree that most people would still consider it to be immoral? You agree? So most people will say this is an unethical or immoral act, but it is no longer an illegal act. And India is also an example now. Okay, is this clear? So you see an example of what is immoral, what might be considered immoral, but is not unethical. Yeah. To diminish which act? No, this is actually not an act. Here we say the act is the Indian Penal Code, which we call IPC. Okay, this is the act. Okay, or the statute. Okay, and this is only a section within the act. They have the power to do that. That's part of the interpretative role, the role of the judges in interpreting the law. That's part of their role. One is to interpret normal controversies in the law, in the interpretation of the law, to decide controversies. And the other is, as you can see, what is happening with many acts. What happens is the constitutionality of the act is challenged. Like earlier when we had like there's an act in bankruptcy law called SARFAESI Act. You might have heard of this, securitization. It's a big name, but it's about recovery of debts. Okay, even the Debt Recovery Act, Direct Recovery Tribunal Act, DRT Act, all of those acts, when they were passed, they were challenged by people said that these acts were not constitutional. So the constitutional validity of an act is also one of deciding the constitutional validity of an act is also one of the roles of the judges in interpreting the law. Is this clear? That interpreting a law means when you take a new law, like say for instance CAA has been challenged now recently, so the judges will look at that law and they will interpret this law and see whether it is consistent with the Constitution. If it is not consistent with the Constitution, obviously any law will be struck down. So here also what they have done, in this case they have not struck down a law as such, but they have struck down a section of the Penal Code. They have said a section of the Penal Code is violative of Article 14, which is equal treatment. and they've said this discriminates against women, so this can no longer be enforced. So now you have a situation which is illegal. This situation is no longer illegal adultery, but is most likely to be considered immoral by most people. This is clear. So all we are showing you here is that you don't have to go into the details of this. I'm going to just make everything here. Whatever is optional in these notes is put into italics. I didn't want to put into italics initially because if you wanted to get into the details of how to read a section, there are certain italics which I have applied here. So that's why I did not put into italics. But so I'll leave that here like this. But you can know that this is just for the sake of giving you the example. You don't have to understand this section and remember this section or anything like that. All we are showing you here is certain things are considered immoral, but they may not be illegal. That's all. So it's clear. Okay. So we are moving on, and now once again matching morality versus legality. Morality is more like normative or positive? Normative, right? Because morality is going to be different for different people, right? Different people would consider different things to be immoral. Okay, so therefore, and then legality is more like positive because you know what is legal or illegal. Like if you want to see the Companies Act, like here's a section from the Companies Act in chapter 3, section 23. Here, what you want to know what to do with respect to prospectus when you're making a public issue, etc., public offer. This is what it is, and what you feel about all this is not really so relevant. This is the law, so it is kind of objective. It's like me saying that switch on the AC whenever it gets to 16 Celsius. So that's very clear instructions for everybody, right? So there's no question of personal viewpoints. All right. Okay. So that's another distinction. So these are all distinctions that we are discussing. Here we come to the last set of distinctions that are going to be discussed as part of your syllabus, which is very important from a judicial interpretation, understanding judicial interpretations. Okay, which is on the one hand we have these two, okay, and on the other hand we have these two. So I will only talk about formalism versus realism, but when I do that, you have to understand that I'm talking about positivism, formalism on one side versus this and this, okay, on the other side. Okay, so we'll talk about formalism and realism, but let's just briefly understand what legal positivism is. So if you see, legal positivism started as a reaction to natural law legal theory. Now this thing you'll understand, you can relate to it very easily from what is going on in the country today. Natural law legal theory was just a view that the authority of a legal standard necessarily derives from the moral merit of these standards. I put the key words in bold. Okay, what does this mean? You can see it firsthand in what's going on in the country today. Like many people are saying that, like say Mamata Banerjee has said that we will not enforce this, will not allow the CAA to be enforced, because essentially what she's saying is that according to me it's an immoral law, right? Immoral or unethical or unfair or whatever, right? So she's saying that. So many other people are also saying that. So we will not allow. Some of the states are saying we will not allow it to be enforced. So what they are essentially saying is that this is the law, obviously, which has been passed by Parliament and signed by the President. So officially it is a law and under our Indian constitutional framework. But what they are saying is, no, we don't recognize the authority of this law. So the authority of the legal standard, we don't recognize the authority of the legal standard, okay, because according to us, this law has no moral merit. This is what they're saying? You understand what they're saying? So what? Yes, Rishabh, you agree? What? No. You know what these people are saying, like those who are taking this position, that we will not allow it to be enforced. So what we are saying is that means they are not acknowledging the authority of the legal standard. The law can be seen as the legal standard. So we are not acknowledging the authority. We don't accept the authority of the legal standard. Because why? Not because we are saying that the President has not signed this law or it was not passed by 2 houses of Parliament. No, we are not saying that. We are saying we don't accept the authority of the law because according to us, this law has no moral merit. Moral merit, you understand? Moral, it has no moral merit means according to me it's immoral or unethical or unfair or whatever. These are all related to moral merit. You agree? Yes? Sahil, you're following the logic, what we are describing? The position taken by these people is that when they say that we will not allow this to be enforced, because what they are criticizing, basically saying it's unfair or discriminatory or whatever. So in a way they are saying that this is not immoral. Is that a fair description? Yes? You don't agree with my description. Is it fair to say that we can say that it's like they're criticizing the law as being immoral or unfair, unethical? Yes or no?
Yes, sir.
Many people are not convinced. I think Chinmay is also not convinced. But my description, you agree with what I'm saying? That in a way what they're saying is that this law is not moral. Yes, that's what they're saying. Similar to that? Yes? Yes. RJ, don't talk to him, talk to me. Okay, guys. Now I need my gavel. Okay. Alright, so you get the point I'm trying to make? So what I'm trying to show you a situation from a real life situation in our own country today, where people are applying this kind of thinking, where they're saying that we don't recognize this law. That means for us this law has no authority. We don't recognize the authority of this legal standard because we think it's an immoral law. You get the point? Okay, so this is a style of thinking which was prevalent even in the UK. You can see it in many countries. This is a natural human tendency. Many people can react like this. So it exists in many countries. So in, let's say in England at the time of John Austin, which is the early 19th century, where you had this same kind of problem, and this was the thesis of the natural law legal theory people. Those who believed in natural law legal theory, they used to say these kinds of things. They used to say that we will decide the authority of the legal standard based on what we think is the moral merit of the law. Whether the law is moral or immoral, that will determine whether the law has authority or not. Are you following the position? You don't have to agree with it, but we are trying to understand the position. Is this clear? So how did positivism emerge? Okay, this is an important idea. How did positivism, so John Austin, so you understand the situation here? Okay, what we are talking about. Now John Austin, it's a reaction. So positivism was a reaction to natural law legal theory. Okay. Quiet guys, don't talk between yourselves. Okay. So what he's saying is, what John Austin is saying, he came up with legal positivism, and then what he said was that this is not acceptable, that the existence of the validity of a law depends on socio-political facts and not on its moral merit. So he's opposing this view. Okay guys, quiet. What happened? So what John Austin is saying is something like this. Let's relate it once again to our CAA controversy. What does he mean by? He says that the validity of a law depends on what happened here next to Mukul. Who's this? What is the problem? You have some question? Then don't talk between yourselves. It's very distracting for me. When I see people talking or I hear any noise, okay, it's like a second soundtrack going on. Okay, guys, so what is John Austin saying? John Austin is saying that you guys from natural law legal theory, you're saying that if you don't consider the law to be moral, you will not accept the validity of the law. This is not correct. The validity of the a law depends on socio-political facts. What are socio-political facts? What he means by that is how the law is made. So in India, this kind of socio-political fact is the fact that the law was he would say that CAA is valid until the Supreme Court decide unless the Supreme Court decides that it's not constitutional. Otherwise, it's valid because it has been passed by both houses of Parliament. It has been signed by the President. So it is a valid law. Are you following what he's saying? By socio-political facts, he's referring to the process of making the law. So if he's saying that the process has been followed, right? Like there were some acts I remember one act from Bengal which was not valid because the president had not signed it. There was a requirement for the president to sign it, but he had not signed it. So unless you can point out that kind of procedural problem, if the law has followed this system, that is Parliament, both houses of Parliament have passed the law, the President has signed the law, now it is a valid law. Whether you like the law, whether you think the law is moral or immoral, is of no consequence. Okay, it does not affect the validity of the law. Because in England that time there was a debate about how should we decide the validity of the law. And so John Austin came into this debate and said that this is how you should decide the validity of the law, okay, that based on whether or not it has satisfied certain conditions, like the way that the law should be made. Like in England, the Queen has to sign. Okay, so Parliament passes and the Queen has to sign the law. So therefore, if that is done, then it's a law. And the moral merit of the law is of no relevance for determining its validity. Is this clear now? Okay, you understand the positions. Okay, you can agree with either position, but we are trying to understand the position. So this is what positivism is. Okay, so positivism says it tries to focus on this and on the process by which the law is made and not on the moral merit of the law. And so formalism is very closely related to positivism. Okay, it tries to focus on the text of the on the actual law. Okay, that is to express. If we go back briefly, let's say at this point of time, let's briefly go back to the. Are you guys getting bored? Yes. So now section B is getting bored more easily. But you have to understand these concepts. Yes, Muskan? Now again, we have created another buddy group here. Okay. So now please try to understand these are just concepts which we are trying to cover, which are important to understand how judicial decisions are made, because we are coming now to the judicial philosophies. Okay, formalism versus realism, which is very important to understand. So try to understand this. Even if you find it a little boring, try to understand the concept. Yes, Mehul.
Sir, I am clear with the concept of legal positivism.
Okay, so positivism is, first you have to understand that it came as a reaction to let me just search for. Okay. Alright, so first thing you have to understand is that legal positivism is a reaction to natural law legal theory. That was the prevailing sentiment before John Austin came onto the scene, right? So, and what was natural law legal theory all about? It was all about taking these kind of positions, which you can see people are taking today, some people are taking today in our country, some of the state governments, where they're saying that we don't accept the validity of this law because according to us this law is immoral. So what they're saying is that actually that means the rule that they're using in their head is that the validity of the law depends upon the moral content of the law, the moral merit of the law, whether we think it is moral or not. Are you following the thinking? This is the thinking. Okay, so John Austin comes into this debate and says, no, I don't agree with this, that the validity of the law depends on certain process related socio-political facts, okay, such as, for instance, whether both houses of parliament have passed the law and the Queen has signed the law, which means Queen is the head of state like our president. Okay, so if the Queen has signed the law, then it's a valid law. Okay, and in the UK you don't have this concept of the judiciary deciding on the constitutionality of the law. The UK system is a parliamentary sovereignty system. So whatever Parliament says in the UK, whatever Parliament decides and the Queen signs, that's the law. The UK Supreme Court generally has no, recently they have started to create some problems, but in general the UK follows a parliamentary sovereignty system. Okay, so the UK Supreme Court cannot comment on Parliament's laws. Parliament, whatever they say, is supreme. So this is what John Austin is saying, that the validity of the law is not a function of the moral merit of the law, it is a function of certain socio-political facts and conditions. Like if you follow the process of making the law, passage through both houses of Parliament, signed by the head of state, now it's a valid law. Whether it's moral or immoral according to you is of no consequence to determining its validity. Is this clear?
So then this is a type of concept rather than a statement.
Yeah, it's again this position that he took himself. This is also a normative position in some sense, because he's saying that you should not follow at a high level. This is a normative position in some sense. Okay, but maybe you're confused by the legal positivism term, because positivism here tries to focus on what the law is. But at a very high level, if you see at a very high level as to what principle, when you're discussing what principle should be adopted for determining the validity of the law, at that high level, these are, in a sense, this is a normative debate, because there's no way to say that this is really wrong. It's just that you have to convince people with your logic, and John Austin managed to bring along a lot of people by convincing them that the morality of the law should not be a factor in determining its validity. It's a point of view, okay, but what he's saying is, what is the point of view? Why is it called positivism? Because he's forcing you to look at the actual lawmaking process, the reality, the reality that is there, that has been that we see with respect to the process of making the law. That's why it's called legal positivism. Okay, so I understand why you have this question. Okay, but is this clear now what it is? Okay, so positivism essentially is saying that look at the look at the process of making the law. Okay, and that is what determines the validity of the law. Okay, so formalism is related to this kind of thinking. Formalism is the more important concept from a legal point of view for us. Okay, but it's important to be aware of legal positivism. What is formalism? Formalism essentially is, I was taking you back to the separation of powers. Okay, taking you back to the separation of powers, if you remember. So in legal formalism, what we try to show is a high degree of respect for, it's a way of approaching judicial decision making. Okay, remember the judge's job is to make the law, is to interpret the law. Remember that? You can see that the judge's job is to interpret the law. Now, while interpreting the law, sometimes remember this concept of why I'm saying formalism is related to positivism, because I'll give you some examples to show you that there are many times when judges may decide cases. Okay, while deciding cases, they go outside this role. This is a role for the judiciary. The role of the judiciary under a separation of powers framework is, the role of the judiciary is to interpret the law, right? Not to make the law, because who's going to make the law? Legislature is going to make the law, but very often the judiciary actually ends up making the law. I'll give you some examples. Like about 7 or 8 years ago, we had a judge in the Madras High Court. This is a real case where the judge in the Madras High Court actually said that if a man and a woman have sexual relations, then they are deemed to be married. Now, the state of being married is actually something that is governed by certain laws in the country. Like we have the Hindu Marriage Act, we have the Special Marriage Act, all these kinds of acts which govern different types of marriages. So who has made these acts? Parliament, right? So these acts are made by, so the question of whether two people are married is actually determined according to certain laws made by Parliament. Okay, so under the Hindu Marriage Act, you have to do the 7 rounds around the fire. So actually, if you do 5 rounds, technically you're not married, even under the Hindu Marriage Act. Okay, so now what is this judge saying? So now you take an example. What is this judge saying in the Madras High Court? It's an actual case where he said that if a man and a woman have had sexual relations, then they are deemed to be married. So if a man and a woman have sexual relations and then they go through a half marriage where they go through only 5 rounds, then what will happen? In the eyes of the law made by Parliament, they are not married, right? Because Parliament requires 7 rounds, okay, for the Hindu Marriage Act. Now, but in the eyes of this judge, they are married. Are you following what I'm saying? Because the High Court is actually the rules of the country require that the district courts which are lying beneath that particular High Court under the Madras High Court, they are all required to follow the decisions of the Madras High Court. Okay, so all these district court judges would all be bound by this. Now here's an example of where a judge actually goes outside the role defined for him. Now you realize that in this particular case where the Madras High Court judge says this, do you realize he's actually making the law?
Yes, sir.
Can you see that? He's making the law because the law is pronouncing on the question of who is married and who is not married. That decision has been made by Parliament by defining certain conditions under which you become married, right? But this judge is going beyond that and he's making the law. He's remaking the law. Are you following? Okay. So this is an example of legal realism, which I showed you as a contrast to legal formalism. We are trying to understand formalism. We can understand it better in relation to legal realism. Okay. So here's an example of legal realism. I'll just come to you. So here's an example of legal realism with this Madras High Court judge's decision to say that if a man and a woman have sexual relations, they are deemed to be married. Deemed to be married means effectively they are married in the eyes of the law. All right. So this is an example of a violation of legal formalism, and this is an example of legal realism, which is obviously opposed, right? If I'm contrasting descriptive versus prescriptive, that means prescriptive is not the opposite of descriptive. Okay, so realism is the opposite of formalism. Okay, so in formalism, what we try to do is we try to be very careful. A judge who believes in legal formalism will be very careful to ensure that he is only interpreting the law and he is not doing what this Madras High Court judge did, which is making the law or remaking the law. So in formalism, a judge tries to show great respect for this kind of constitutional structure and the separation of powers doctrine, where they try to be very, very careful about only interpreting the law and not remaking and making the law. Okay, we'll give you another example later of making the law or remaking the law by the judiciary. But are you getting some idea now? Yes, Rishabh, what is your question?
In this situation, they are married or not?
No, in this situation, what would have happened is, see, the problem for the district court is they would have to send it up to the High Court, Madras High Court, okay, to the Chief Justice, because there's a conflict now. Because this judge is saying that if you have sex, you are married, and the Hindu Marriage Act says that unless you go 7 rounds and some other conditions are fulfilled, there are some bars on marriage and all that. So unless all those conditions are fulfilled, you are not married. So there's a conflict between the Hindu Marriage Act and the judge's decision, right? So therefore, the district court would have to send it up for the High Court full bench decision or division bench decision, clarification. Eventually, it would go up to the Supreme Court. It might go up to the Supreme Court for clarification. But actually, eventually, what this judge did was not correct. So it would get shot down. But the problem is, it does create a problem for the district courts in the short term, right? Because it slows down the decision making, right? Yeah.
So when we
1 minute, Jakar will go first.
Then legal formalism can
Okay, the rest of you guys, yes, Sonakshi. No, sorry, I keep getting your name wrong. I'm very sorry. Sonal, okay, so I'm getting close, okay? So, okay, no talking. When one person is asking a question, everybody else should not get into a talking mode, right? So please concentrate on the question, okay, yes.
unless we have legal formalism,
Quiet here, quiet, yeah.
unless we have legal formalism, we can't execute legal formalism. And that's why it should be considered, and that's why you are taking it as similar.
No, I didn't understand your question. Unless we have, I understood the first part. Unless we have legal positivism, we can't have legal formalism. Yes, I agree with that. That's a good assessment. Yes.
Therefore, legal formalism is considered.
Quiet, guys. Quiet. I need to hear his question because we don't even have mics in the class right now. I need to hear his question clearly. Everybody else be quiet. Yes, Arushi, don't encourage her. Focus on the question. Okay.
I wanted to establish a relation between positivism and formalism.
Okay.
So what I thought was that when you have legal positivism, then only you will try to implement legal formalism.
Yes, you're right. You're right.
Therefore, legal formalism will be a subset of legal positivism. So this is how I related the two.
Okay. Yeah, I suppose you could make that statement. It's a little bit of a strong statement. I'll have to evaluate properly and see whether, because if you make a strong statement, they have to see that its statement is valid under all conditions. So, but I get your idea, that your idea is very much correct. So at this point, I would recommend you just keep it at the level of that idea, that without a belief in legal positivism, you can't have legal formalism, because that's the same kind of philosophy. That's why I've grouped them together, right? Okay, so you get an idea about formalism. We are trying to understand formalism in contrast to realism. Yeah, 1 minute. Mehul has also has a question before that. I'll just come to you. So the idea here is, the first idea that I'm trying to give you is that in formalism, remember formal means quite strict, that I want you to come to class wearing a suit and tie and everything. No informal, casual attire. So here formalism has this concept of strictness, okay, which means strictness in adhering to the separation of powers doctrine. What is the role of the judge? Only to interpret, not to make the law. And also basically formally, like what he pointed out, that we follow the strict, we focus on the strict process. The law was passed by Parliament, therefore it's a valid law. It's passed by Parliament, signed by the President, it's a valid law. It went through the process. Okay, so it's that kind of, you get the philosophy, you get the picture, right? That it's a kind of a formal belief in the process, okay? And that's what formalism really is about. We'll give you some more examples. And in contrast, we showed you one example of realism, where a judge in the Madras High Court goes on to remake the law and then strays outside these well-defined boundaries. Yes, Mehul, what was your question?
So when he goes beyond his boundaries and he makes the law, will that law be implemented?
No, as I said, what will happen is, as somebody was asking this question, what will happen? I think Rishabh was asking the question. So what will happen? No, what will happen in this particular situation is that it creates, what it does is it slows down the judicial system, because it creates more confusion. In this particular case, what will happen is, because the lower courts are bound by the Madras High Court decision, the district courts will now be confused. Should I follow this judge's decision because it's conflicting with the Hindu Marriage Act, which has been passed by Parliament? right? So they will have to send it back to the High Court to resolve the conflict. So it slows down the decision making. In this particular case, eventually a decision like this would get shot down in India, okay? Because we don't allow this kind of, more or less the philosophy is there, but it will slow down because the High Court judge still has that power. Nobody's going to punish him. Understand that what he has done, he's not doing anything illegal because there's no law that forces him to follow formalism. So that's why many judges, this is just one example, many judges create these kind of problems. They throw spanners, it's like a spanner in the works. You know the expression? Spanner in the works means I jam up the whole process. I throw a spanner in the machinery and it jams up the whole process, right? So this is what many judges do, right? Yeah, 1 minute. Before that, I'll come to Krish.
So yes, the recent road safety bill was implemented and many states has denied that they will not implement it. Then there is a problem between legislature.
Yeah, see, in that case, I don't know whether, I think we have to look at the competence aspect. You know, in India we have the competence aspect, but assuming that the central government was competent to enact laws on that matter, okay? So in that case, if there is, this whole business is similar to the CAA problem. Many states are saying we will not implement the law. Actually, under the system in India, we can't do that.
CAA has been challenged in this way, but the road safety bill has not been challenged.
Not been challenged. So in fact they can't do that because central law will supersede state law. That's how India works, okay? Most countries work on that basis. Even in the US, which is a very decentralized system, states have a lot of power, but there's any conflict between the central law and the state law, the central law will prevail, even in the US. So all other countries which are much more centralized like Canada, India, in all these countries, any conflict, central law will prevail. So that's a general principle. Okay. So yeah. So where was that? Okay. Anybody else has? So you also had a question. Yeah.
In legal reality, there is always a violation of forgetting the law, or there are other violations of it as well.
No, generally that is the type of violation of this structure. That is what you see in legal realism. That is the kind of violation that you see where the judge brings his personal. Remember one more thing, that when the judiciary is interpreting the law, I'll give you some examples later on, we'll see that if a judge is following formalism, okay, what Munira is asking is, it's a good question, that whether when we are talking about legal realism, we gave one example where a judge following legal realism, which is the opposite of formalism, went on to remake the law. So she's asking that this was a violation of this structure, okay, and in realism, is that the only type of violation that happens, or other types of violations happen also? So the answer is that is pretty much the only type that happens. That most of the cases of realism, what happens is judges who believe in that philosophy, they will essentially use their power to remake the law and to ignore the actual law that is on the books. Okay, so we'll see more examples of that. Okay, so this is the idea. All right, so any other questions at this point? Okay, so let's go on further to understand. You'll understand it better when we see some examples. Yes, Bhavya, you have a question? Okay. So, all right, so this is one of the points to understand when you're talking about formalism. Formalism is a broad view based on structure and process, that you respect the separation of powers idea. Okay, the role of the judiciary under this particular scheme is only to interpret the law, not to make the law. If any law needs to be made, it should be done by the legislature. The judiciary can feel that there is a part where the law is not clear. The role of the judiciary is to send it back to the legislature, say that please make some amendments and clarify this point, because they should not be making the law. This is the formal view of that you see in legal formalism. Okay, so this, and then therefore obviously and there are certain sub aspects of formalism. Let me just go down further and just talk about it. These are very important. Both the doors are open in your class. We should actually maybe not have both the doors open. Can you shut it fully? Just slam it shut so that we don't get any noise from other classes. Okay, so you have some idea about formalism now. Okay, let me give you another idea of formalism before we go into, and I'll give you another idea of realism also. But before that, let me just go down the case a little bit and talk about one very good example of formalism. I hope I didn't. Oh, I should not have closed it. I don't know, sometimes should not have closed it. Okay, because many things are blocked. Okay, all right, guys. Now, what is happening here? This is another thing that is happening. People keep leaving from the class. Okay, this is another thing which I'll have to crack down on eventually, because in your seniors, in the case of your seniors, I had to do this. That if you leave the class, you have a break in between, because it's very distracting for the teacher. What happens is one person is leaving, as soon as she returns, another person is leaving. So it's like a constant parade going on in the class. So it's very distracting for the teacher. So I'll have to crack down on it from now on, that you have a 15-minute break and I don't take much extra time, maybe 40 seconds. Okay, so you are required to take care of your water bottle filling, everything you want to do. Use your 15-minute break, because if you leave in the class, I will deduct marks. Okay, unless it's a medical emergency. If I see somebody looking generally sick, I never stop people. So in that case it's different, but otherwise you can't just go out. Okay, all right, so let's understand once again with a very good example. Let's understand formalism. You guys remember that in 2015 there was this controversy where this Nirbhaya convict, the juvenile convict, was being released from prison, and everybody was very angry that he should not be released, but the Supreme Court allowed him to be released. Okay, so this is that decision. So the Supreme Court refuses to block release of the juvenile. Now look at what the court is saying. I think here you will understand very well what is meant by legal formalism. Now here's a very good example of legal formalism. Read this. Is it clear to you? If you can read, can you read, Janmeet?
Yes.
Okay. Read this and see for yourself. I will also add one more thing. That will make it very clear. Legal positivism, the law, as Jacker very correctly pointed out, very good point actually, that you can't have formalism without positivism. So first you have to acknowledge that the merit of a law, the validity of a law derives from the process by which the law has been made, were certain socio-political facts, and not on the moral content of the law. And then you have a formalistic view of interpreting the law. So can you see what's going on here, guys? Certain very key words. So this is what the Supreme Court said in refusing to block the release of the juvenile convict, right? So they said, what is this? Formalism or realism? Court has to go by the law as it stands today. All right, so it includes the idea of positivism. What is the law? What is written here? Not what I consider moral or immoral. Because here, if you went by your morals, okay, what is the court saying? We also share your concerns, which means maybe the court, these two judges, Goel and Lalit, maybe these two judges, they also were morally outraged by the fact that the juvenile was going to be released. Maybe they also believed that it was immoral to release the juvenile. But they have not allowed their own views of the morality or ethical nature of some action to influence their interpretation of the law, because they are respecting the separation of powers. Their job is to interpret the law, which is a strict belief in what the law actually says, right? The court has to go by the law as it stands today, even though we may be also morally not comfortable with releasing him, but we are releasing him. And what is he saying? Further, if you want the court to further detain him further, clear legislative sanction. Who will give the legislative sanction? Legislature, among the three branches, the three organs of state. Okay, who will give the legislative sanction? The legislature will do it, which means, does it show respect for separation of powers?
Yes.
Can see that? Okay, please inform her in the future. If you go out, you'll lose marks from the next class onwards. Okay, you need to take care of everything in the breaks. That's why the breaks are given. So okay, guys, now very important to understand this philosophy, because this distinction is very important, because it actually affects it actually affects the way that decisions are handed down by judges, okay, in the courts on a daily basis. But in India, we don't have an active debate about the difference between formalism and realism, and which is better and which philosophy should we follow. We don't have the active debate, but in fact what happens is some judges follow formalism and some judges follow realism. So as a result of it, you can get all kinds of funny decisions depending on who the judge is, right? So clearly you can see legal formalism from this decision. We have to go by the law as it stands today. We may also have discomfort morally with the law, but we will not allow that our moral views to come into the interpretation of the law and the decision in the case. Is this clear? And if the law has to be changed, who has to change it? The legislature has to change it. We are not going to remake the law. If you want any remaking of the law, it has to be done by the legislature. Is this clear? Showing respect for the separation of powers doctrine. Very important to understand this philosophy, so I'm spending a little bit of time on this. Okay, now you understand from some real examples what this is. Okay, so now you understand very well what formalism is. I'll just give you one more, and realism is basically the opposite of formalism, where in this case, if it was realism, these same judges, if they believed in legal realism, what they would have done is they would have blocked the release of the juvenile, then said that even though the law says this, but it is not good for society, and all kinds of blah blah blah, all kinds of stuff they would come up with, and they would find some reasons to say that this law essentially going back to natural law legal theory, saying this law is not valid because it is immoral, because it is leading to the release of the juvenile, so we should block his release. Is this clear? If they followed realism. Yes, nobody is getting confused, I hope, right? I'm saying if they followed realism, that's what they would have done. In this case, they have followed formalism, so they have not blocked the release. They have allowed him to be released. Is this clear to everyone? Yes, Saloni, are you following? Okay. All right. Okay. So now I'll give you one more example of realism. Okay, so you can read about all these things later on. Instrumentalism is the same as realism. It comes from the same philosophy. I'll just give you briefly what realism is. So realism basically says that it's perfectly fine for decisions to be made based on the moral views of the judges. That's what the system is supposed to do. You don't have to follow the actual text of the law. The moral views of the judges coming into the decision making, that is perfectly fine. Okay, so that's the philosophy, legal realism. Okay, so that's why I said that as far as the choice of formalism or realism, that choice is actually a normative choice. You can't really prove that one is wrong or the other. But once you get into formalism, that becomes a very strict, positive, formalist kind of interpretation. Okay, so what was I talking about? I'll give you one more example before I go. Okay, now many of you might have heard about the Shabano case. It's a very important case in Indian judicial history from 1985. Okay, so I'll just briefly tell you. This is all in italics because it's optional. I don't want to spend time on it. If you want to read, I didn't delete it because those who want to read further can read it. Okay, I'll just briefly discuss. All we want to care about the Shabano case is that all we are interested in is that this is a case, this is an instance of legal realism. This is an instance where judges followed realism. What did they do? So here you have this woman. So she's a Muslim woman. She was divorced by her husband. Okay, and she didn't have any money. She was quite old, also I think 68 or something, and she was quite old. So basically, she was out on the street. She didn't have any money, and so she filed. There's a provision in our CRPC, the Code of Criminal Procedure 125, which deals with maintenance. Okay, so basically, any man who has sufficient means has to maintain his father, mother, wife, children, everybody. Okay, and wife includes somebody who has been divorced but has not remarried. Okay, so Shabano applied under this provision, and because she had not been remarried. Okay, so therefore she applied for maintenance, and she got maintenance from the lower courts, and it was all approved by the higher courts also. Now eventually what happened, even when it came to the Supreme Court, the husband had argued against that. Okay, so and when it came to the Supreme Court also ruled in her favor and gave her maintenance. But actually this is an example of realism. Why? Because under the law, if you look at the law strictly, she was not entitled to get any more maintenance from her husband. Okay, so let's see why. So in the CRPC, this is called CRPC, Code of Criminal Procedure. Okay, that is Criminal Procedure Code. So CRPC. Okay, so here there's another section 127. So 125 gives you the right to claim the allowance. 127 actually says that there are certain cases when the allowance will be cancelled. The court will cancel the order for allowance. Okay, what are some of those cases? One of those, let's look at 127(3)(b). Now the woman has been divorced by her husband and she has received the whole of the sum, etc., etc., which under any personal law was payable on such divorce. Okay, so this is clearly referring, remember these things are written by the Brits. These laws were all written by the British. The philosophy of the British was that we will take out all the economic wealth from this country, but we will not interfere with the locals and let the Hindus manage their own affairs, let the Muslims manage their own affairs. We are not going to interfere with their personal laws. Okay, so one of the things that they did here, because of that, now this provision, if you see, was clearly meant to include, because under Muslim personal law there is a provision that there is a concept of dower, meher or dower, which you have to pay before the either you pay at the time of the marriage or before the marriage, or if it has not been paid, then you must pay after divorce. Okay, within a period after divorce. Okay, so in this case she had been paid that money after she was divorced. Okay, in this case Shabana was paid this money, and if you look at the law as such, strictly as written, this provision was meant to exclude the Muslim community from the provisions of 125. This was written by the British. Okay, so they said that we don't want to interfere with the personal law. So where the personal law is providing for some payment to be made on divorce, okay, which is the money that if you have not paid it at the time of marriage, you must pay at the time of divorce. Okay, and this woman had received this money. Okay, she had received this money. So strictly speaking, under the law, and this is what her husband argued, that she's not entitled to anything more because of this provision. Okay, but the Supreme Court, what did they do? They realized that strictly speaking, if you go by the law, she will not get anything. But then what will happen? This poor woman, she is going to be out on the streets. She is an old woman and she can't earn anything. So she's an old woman, and now what will happen? So what the Supreme Court did was, they gave her some additional maintenance. So they ignored the actual text of the law, because under the actual text of the law she would not have got anything more, and they gave her some additional amounts. Okay, and how did they do that? They said basically they used what is called a purposive approach. So they said that what is the purpose of what have I done here? I can't even see what I'm clicking. Okay, or what I'm typing here. Okay, so what did they say? They said that the purpose of 125 CRPC is to prevent vagrancy. You know what vagrancy is? Vagrancy is homelessness, essentially. Like a person is out on the streets and just walking around, no place to go. Okay, so they said that the purpose of 125 CRPC is to prevent vagrancy. Okay, so what we are going to do is, and if we read the law very strictly, then what will happen is this woman will not get any more money and she will be out on the streets. So that will defeat the purpose of the law. Are you following the logic? Okay, so that's why this is called a purposive approach, where you try to look at what is the purpose of this law. When there's some apparent conflict, you think there's a conflict between the purpose of the law and the strict letter of the law. Okay, there is some confusion that is coming up. So what they said was basically that if you look at the purpose of CRPC, if we follow this exception and don't allow her any more money, she will be out on the streets. It will defeat the purpose of the law. So we cannot allow that to happen. So therefore we are going to ignore this part and we are going to give her some more maintenance. Okay, so that's what the court did essentially. So here I'm citing this as an example of realism. Okay, you understand what is going on here? The court is reading the law strictly. The court sees that if you read the law strictly, she will not get any more money, and so what will happen? You will have a result which the court considers to be immoral. That woman will be out on the streets, old woman will be out on the streets. That court considers this to be an immoral or an undesirable result. Are you following the logic? Okay, so the court does not think this is a fair or just result. So justice is also often used, that this is not a fair or just result that an old woman should be out on the street. So the court ignores the strict letter of the law and uses ideas like the purpose of the purposive approach to interpreting laws. What is the purpose of the law? And finds a way to do what the court thinks is correct. Are you following the logic? the court thinks this is the same as this is why it's realism. In realism, what does the judge do? The judge decides what is the correct outcome in the case. The judge decides what is the correct, beforehand he decides when he looks at the case and decides what is the fair and just outcome in the case, and they give the judgment in such a way that the outcome is what they want, what they think is the fair and just outcome, not necessarily what is written in the law. Is this clear? Yeah.
So realistic and normative approach.
Yes, so that's why we are discussing formalism versus realism as one of these distinctions. So as Munira has already anticipated, our next part of the discussion is, now we go back to normative versus positive and we compare formalism and realism, and we try to compare and match it with normative versus positive. So as she has correctly pointed out, so realism is more like normative or positive? Normative, right? Because you decide what should happen in a particular case, and then if the law is not supporting that view, then you ignore the law and still give the judgment in such a way that you get the result that you think is fair and you think is just. Is this clear? Everyone understands? Okay, so we are not trying to understand that you don't have to agree with one position or the other. We are trying to understand the philosophy. Now this is very important to understand, because as part of your judicial training, that because this is actually going on in India. You will see this going on in India. Some judges follow realism, some judges follow formalism, but we don't have an active debate in this country about these philosophies. Okay, which should we follow? Like we have debates about reservation, this and that, but we don't have a debate about this. So, but it actually affects judicial decision making on a daily basis. So I feel we should have a debate on this, and so I'll just briefly cover a couple of other points here. You can read all this stuff. I'm not going to go through every line. Okay, in formalism, there's a couple of other terms you need to know. Okay, one is textualism. Textualism is basically nothing but the same idea. Follow the black letter law. Black letter law, why? Because laws are always written like this. There's a white background and there is black lettering. So what they're saying, black letter law is an expression we use, which is to say just follow the law as it is written. Don't bring your personal views about morality and all that and justice and fairness into it. Just read the law and interpret the law as it is. So textualism essentially is about following the text, following the black letter law. And then there's a subclass of textualism, which is originalism. These are terms you need to be aware of, which is a theory of constitutional interpretation, which is, again, you can see everything is logical. Okay, so originalism is a philosophy, is formalism applied to constitutional interpretation. Okay, which is that when we interpret the Constitution, we will interpret it based on whatever was the original public meaning of those words in the Constitution. Is this clear? Okay, why original public meaning? Because remember, who has to make the law? Legislature has to make the law. So if I am a judge, my job is not to make the law. So I will read the law in the exact same way that people understood the law when it was written. Are you following the logic? It's all consistent. That originalism means you interpret, like in the US, the Constitution is nearly 250 years old. But they will, when they are interpreting something, if it is actually 250 years old, it was written 250 years ago, they will think about what was the meaning of that word 250 years ago, and they will interpret it that way. Is this clear? You get the logic? Why? Because any other interpretation means that you are making the law. Because if there was some changes required, that was written in, that statement was written in, that word in the Constitution was written in 1790, let's say, and if you want me to change it, that means you are asking me to rewrite the law. If some change was required, it would have been done by the legislature, because you have constitutional amendments. You understand what I'm saying? You can see how originalism is completely consistent with formalism. All these elements are very consistent with each other. That ultimately it boils down to that respect for the separation of powers doctrine, and the role of the judges is not to make the law. So wherever a law needs to be made, they will push it back to the legislature and say that if any amendment is required, I will go by the original public meaning of 1790. If you want me to change it, go and ask the legislator to amend the Constitution. Are you following the logic?
Yes.
Okay, so it's all the same. It's all consistent here. Okay. Now, just briefly here, a couple of other points. I just want to explain the sentence to make sure that you're aware of how to write these things. How not to how to write it in an exam or something. How to understand the statement. We also discussed descriptive versus prescriptive. Remember? Okay. So we had a long discussion about formalism and realism. Okay, you can read about formalism and realism here. Okay, and instrumentalism is the same as realism, very similar. Okay, now what are they saying here? That formalism and realism can be understood either in a descriptive or in a prescriptive way. All right, what does that mean? That I could, like this discussion I've had with you so far, what am I trying to do? I'm trying to explain what formalism is, explain what realism is. Have I said anything about which one I think is a better method? No. So I'm only so this discussion so far about these two topics has been conducted in a descriptive way, because I've tried to describe to you what these things are. Okay, but now if I go and tell you that where is this? Now if I give you my personal view, which I should also do, because you just have to make, not because you should agree with my view, but you should know what a view is, what a view looks like, and how it is justified. You should learn that. You can adopt any view, but you should know what a view looks like and how it is justified. So I prefer formalism because in formalism you have a greater probability of certainty and consistent results. Okay, why is that? Think about it. If every judge is forced to follow the text of the law, whenever any decision on public offers, you have to follow this section and other sections. So if every judge is being forced to follow the strict text of the law, do you think it's more likely to lead to consistent decisions? Because how much can you differ when it comes to interpreting words, right? Unlike realism, where you say that in the Shabano case they completely ignored section 127(3)(b). So there you have more room for subjectivity, because you're allowing, under realism, you're allowing judges to say that, okay, the written text is not so important. What is important is, what do you think is the moral course of action? What do you think is the fair course of action? Are you following the logic? Right? So under realism, you have greater risk of, and moral, what is morals? Morals are subjective or objective? Subjective. So my morals will be different from, say, Chinmay's morals, from Krish's morals. Everything is different. Everybody's morals are different, right? So now if three of us are judges, I'll give one kind of decision, he will give one kind of decision, Krish will give some other kind of decision. So what will happen is that there is a greater risk of all kinds of incoherent and inconsistent decisions. Are you following the logic? Yeah. So those who prefer legal formalism like me, one of the reasons we prefer it is because forcing people to stick to the text gives you a higher probability of giving consistent results, and that is one of the important functions. The result should be consistent. Okay. Second is that it's a formalist view, that it forces the judges to remain in the role of only interpreting the law and not making the law. Is this clear? Okay, so these are some of the reasons why people who prefer formalism do so. These are the justifications that they give. All right, so these are some of these points, and I think we have covered everything here. 1 minute. Yeah, here there are some. So in general, everything is. I didn't put this in italics, but I'm just telling you that this is this is optional. Okay, you want to study this MOOC, you can study this MOOC. I don't think it's very good, but it's on the topic, so I've given it to you here. Okay, everything is okay. Now I'm just going to point out a few other things. Okay, this entire discussion that we are having, instrumentalism, very similar to realism. Okay, I've given you all these discussions. Okay, on the Shabano case, guys, quiet. While the class is going on, I don't want to hear any of this murmuring. Okay, should be very quiet. If you want to read, all this is optional, all in italics, but if you want to read more, after the Shabano case, there's an act which the parliament passed. Then there are some other famous cases, Daniel Latifi, these kind of things. If you want to read, you can read it. Okay. Now, as far as the syllabus is concerned, we are stopping this discussion now as far as normative versus positive and the similar concepts related to normative versus positive. But if you are interested in learning more, I've given you some more material. Ex ante versus ex post, these are some other distinctions. Consequentialist versus deontological, consequentialism versus deontological perspectives. Okay, so these two are kind of optional for you. This is not part of your syllabus. Okay, so if you want to read more, you can read it. But I would like to check one thing: ex ante versus ex post. Ex ante is before or after? Ex ante is before. Okay, yes, so ex ante is before and ex post is after. Okay, so you should be aware of these terms at least. Okay, because they can come up in other contexts as well. All right, so don't start packing up, we still have some time. People are like, just because I felt like 1 minute. One sec. I have to maintain parity between the sections. So I don't want to see all this crybaby stuff. Okay, I will release you now. You're not babies anymore. You're behaving like class 2 children, you know. Okay, now we are going into 1 minute. We have some time. I'll just briefly cover 1 minute. 1 sec. So we are starting the part B. Now India is a common law system. Okay, common law systems you find in the UK, US. Be quiet now. Bratika, be quiet. Now just behave yourself for 2 more minutes. Okay. In India, you need to know these terms: civil law versus common law. Civil law is what you get in continental Europe. Okay, France, Germany, Italy. Okay, and common law is all the British colonies. Okay, and the main difference between common law systems and civil law systems is what we call judicial precedent. That is, previous decisions handed down by courts. So in civil law systems, which we are not going to study in detail, judicial precedent is not that important, but in common law system is very important. You'll see this when we do our cases. The precedents that are used to decide cases, these are very important. And the other point here is that we have actually most of our systems now in India, US, Australia, Canada, these are mixed systems, because we not only do we follow judicial precedents, that is previous decisions, we also follow codified law. Okay, what is codified law? Codified law is something like this. Okay, codified law here, this is Companies Act. Okay, this is section 23 of the Companies Act. This is what is meant by codified law. Any act, Contract Acts, Transfer of Property Act, these are codified laws, and judicial precedents are the previous decisions of the courts. Okay, and so we follow both. So we are not just a common law system, actually a mixed system, but we still call them common law systems. Okay, all these are called. So there's a presentation here on another point you need to understand. Prospectively is forward looking. Retrospectively is backward looking. Okay, so after the famous Vodafone judgment, we had okay, so I'll stop it here. After the Vodafone judgment, we had some retrospective amendments to the Income Tax Act. Those applied from like before, not just from 2012, but from 1980 onwards, let's say. All right, okay, you can read this presentation. I'm not going to cover it in detail, and we'll go on with the rest. Okay, these are all optional. So I took how many seconds? 40 seconds. Not even 40 seconds. Today, okay. So retrospectively means that Where is it? Like close it or what? Something seemed to have happened. The law anyway. Retrospectively means okay here. Retrospectively means that with effect from before the current period. So if they made some changes in 2012 to the Income Tax Act, those changes would be made applicable from before. So for instance, you're making the change in 2012, but you say that this change will apply from 1980. You say that a change will apply from 1980. You're making the change only in 2012, okay? But you say that the change is going to apply from 1980, which means this change is happening with retrospective effect.
If someone from those times is going to file a case, then you will be applied on that.
Yeah. So if it is retrospective effect means any case, let's say from 2012, you say something applies with retrospective effect from 1980. Now any case which was started in, let's say, 1995, that will now that case will have to be decided, including the new changes from 2012, which are retrospectively applied. So it's actually going. So that is the meaning of retrospective. Going back, retrospective is usually applied with the word effect. That this change will have retrospective effect, which means it will be applied from before. Usually most laws have only a prospective effect. That means you make it in 2012, now it applies from 2012 onwards.
India follows retrospective approach.
No, depends on how they make the law. Generally we follow prospective. Generally all laws have prospective effect, but sometimes they may make laws which will have retrospective effect. But it's quite rare.
I don't know.
Yeah.
So when you gave the example of adultery, Supreme Court has given the verdict that adultery is not illegal in India.
Yeah.
So will Supreme Court has just said that?
Yeah.
It's not a law, right?
No. There is a provision, we'll see, that there is a provision here that the law given by the Supreme Court, Article 141, okay, which basically says that the law given by the Supreme Court is the law of the land. So whatever they say is the law of the land. So now you can't, let's say you want
But judiciary does not have the power to make laws.
so you can say this is an example of realism. You can say this is an example of realism. But at the same time, we seem to have allowed for it because in our constitution it says that, you see Article 141, the constitution says that the law given by the Supreme Court is the law of the land. So we have essentially, here it says law declared by the Supreme Court is binding on all the courts within the territory of India. So that will force everybody to apply according to that.
So does that mean that judiciary and legislators, they both are sharing their powers? Like they're sharing the power.
No,
Supreme
in
Court
this
is also
case,
having the power.
this is clearly a case of realism, where the Supreme Court has decided that this particular provision is no longer to be is unconstitutional, okay, and they have on constitutional grounds they have struck down the provision. So this power is given to the Supreme Court under the Constitution. They can interpret the laws or provisions of laws by judging their constitutionality.
And that is the example of realism.
Yeah, that is an example. Realism is broader than that. Realism is much broader than that because assessing the constitutionality of a law is a very narrow scope because it's only when you challenge the law on constitutional grounds. But if the challenge is not on a constitutional ground, okay, even then you can have realism. Okay, and here the Supreme Court has actually been given power, but even Article 141 actually doesn't say that this is only true for constitutional challenges. So in India we have effectively endorsed realism in the Constitution by giving the Supreme Court this power to say what the law is.
And this realism concept is only for the judiciary part.
Sorry?
The concept of realism is only for the judiciary part. Like the way,
Realism and formalism are methods of
interpretation of
judicial
law.
philosophies.
Okay.
Judicial philosophies. So some judges follow formalism, some judges follow realism.
Yeah.
But in India, we have essentially allowed realism under the constitution because we said whatever the Supreme Court says is the law of the land.
Yes.
Okay, so we've allowed, in a way, we have endorsed realism, and this can extend to any kind of question, not just a question of on something on constitutional grounds.
So the example you gave of the Karnataka judge, if that case,
Madras High Court, yeah.
Madras High Court, yeah. That case goes up to Supreme Court, and Supreme Court, for example, says that yes, this is a law. If two,
In that case, it is the law.
It is
the law. They have overruled the legislature. So that is the law because we have allowed them under Article 141. We have allowed them. We have not said that Article 141 is only for constitutional issues. So although there are some limitations on what kind of cases the Supreme Court can try, but effectively those limitations don't exist because you can apply under special leave petition and all that. So effectively the Supreme Court has tremendous power in India. Tremendous power. Okay.